remain standing until all oral argument time has been granted. When you come up for your case, opponent to my right, respondent to my left. Lighting system, when the white light comes on, you have 2 minutes left of argument. When the red light comes on, please bring your arguments to a close. Cell phones and other electronic devices need to be turned off and put away, with the exception of at the podium. To assist in your oral argument, everyone arguing should have filled out a notice of appearance by now. Thank you. Take a seat, please. All rise. Justices of the Appellate Division Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division draw near. In your attendance, you shall be heard.
Good afternoon. We have more than 4.5 hours of argument time requested, so ask for the time that you need. If we have more questions, we will keep asking them. People versus Stokes, submitted. Tucker versus All Metro Home Care, appellant. No, we're just doing the calendar now, so you just ask how much time you want at this point.
10 minutes.
Respondent?
Respondent request 6 minutes, please.
5, 1, and 5. B. Kevin versus Tanisha is submitted. HSBC Bank versus Aonsa, appellant. Is appellant here? Do you want to just submit it? Okay, 3 minutes. Yang versus Knights Genesis, appellant. Respondent?
7 minutes, please, Your Honor.
5 and 6. People versus Maycock is submitted. Veronis versus 130 East 18th.
Appellate, 5 minutes.
Okay, which appellant are you, though?
I am Unified.
And you're asking for 5 minutes?
Yes, please.
Okay. For 4 minutes?
Plaintiff responded 4 minutes, please, Your Honor.
Okay, 5, 4, 3, and 4. People versus Hernandez?
People 6, Your Honor.
6, 1, and 6. Sarahsaurus Investors versus B2C Alternative Equity Appellant.
Appellate, Your Honor, 7 and 2.
Respondent?
Respondent 5 and 3.
7 and 2 and 5 and 3. People versus Cedino is submitted. People versus Diaz is submitted. Roberts versus City of New York is submitted. Pan West NCA2 versus Rockland NCA2 appellant.
Appellant 5 and 3.
Respondent?
5 and 3 as well.
5 and 3.
5 and 3 were responding across the top.
5 and 3 and 5 and 3. Okay, so the first case is Tucker versus All Metro Home Care. Go ahead, good morning.
Morning, Your Honors. Robert Hiltzik, 380 North Broadway, Jericho, New York. The appellant, Your Honors. Your Honors, effectively, this case is about Brill versus New York City and its progeny. Brill, as we all know, is the gatekeeper for untimely motions, no matter whether they're cross motions or motions. The times of Brill are you either show good cause for the untimeliness, or, Your Honor, you show that your issues are the same as in the original motion.
So let's analyze it a little bit. The note of issue was filed in July,
Yes.
and then through stipulations, everything got schlepped to like November and ultimately December by stipulation, as agreed to. You don't dispute that.
I did, the only caveat to the, Your Honor, is that the respondent had nothing to do with those stipulations. They were not involved at all. So effectively, Your Honor, yes, the respondent's trying to piggyback a motion that was made in July. Now, the note of issue was...
Counsel, why don't these all arise out of the same issue, which is basically whether there's any liability in this case?
I don't think that's true, Your Honor, and I can be specific about that.
Right.
In the original motion, Your Honor, my clients originally, their claims were that the defendant, that is the All Metro, the claims against All Metro were negligent supervision.
Now, to understand there were different theories of liability, but isn't the heart of this whether there is any liability of either defendant for the plaintiff falling or somehow coming out of the window?
Well, that is so broad, Your Honor, but I think
But isn't it appropriate for all of those issues to be decided together on one
Your Honor,
motion?
as this court held in Kershaw, this court held in Kershaw that the evidentiary foundation of the original motion is something that the cross movement would use, and that's what the purpose of the cross motion is. Here, that doesn't exist at all.
What's the court supposed to do when, in looking at the motion, let's say they come to a certain conclusion about the respondent, even though it starts off with All Metro, but you also, when you look at it, you see what should happen to the co-defendant also.
But because the arguments that the respondent would make are completely different than All Metro. All Metro had to fight for the...
We're not talking about that you didn't have an opportunity to respond to the arguments of the co-defendant, right? You had an opportunity to make your case.
Right, but the issues were completely different.
Counsel, can
And
we go?
because it's untimely,
Yeah, can I go back just for a second when you said that they can't piggyback off of those stipulations? Well, do you have any cases that say that another party wouldn't be entitled to the benefit of an extension on a stipulation when certain parties in the case have extended their time to respond?
well, the cases that I do have, Your Honor, are that the 120 days is a firm line of demarcation. There's
Yeah,
no
well-
case law.
I'm sorry. That you're correct on that analysis, but understand that the focus really is prejudice and surprise in a certain context, and we know that the decedent or the estate did put in a cross motion to your original motion with respect to All Metro and the cross claim, didn't they? This is a successive motion that you're getting upset about.
Well, the respondent did file a cross motion against All Metro, but they filed that 2 months before they filed the cross motion against my client. And in fact, in their original cross motion against All Metro, they stated affirmatively, hey, this is within the 120 days. Now, when they filed their cross motion against my client, they neglected to say that because they knew at the time they were
I
untimely.
want to interrupt you for a minute, just because we're running out of time. What's the point of all this if they're just going to get a directed verdict at trial? If there's no basis for any liability here based on the absence of the window guards, which we haven't addressed at all, what's the point of going through the trial, putting on your case, and then them getting a directed verdict?
Well, Your Honor, with all due respect, I know you've heard that all the time, but I think there is an issue because the only thing that we have on the record as far as the information that respondent received was they were told the circumstances of the decedent's condition and the circumstances of his living conditions. The record contains no...
I'm sorry. the seating condition?
So-
Mr. Tuck,
I'm sorry, no, I meant my client. They were told the record shows that the only thing that they're admitting to, they were told the circumstances of his disability. They don't say what those circumstances were, so it's very
Right, but we know
possible.
there's no requirement under the window guard law because he was not under 10. It's not an assisted care facility or any type of facility. And I don't see any type of common law duty you've identified that would impose a duty on this landlord to install window guard.
Well, if they knew the serious, they admitted to the seriousness of the condition, and they do in their.
Counsel,
Doesn't mean
you
a
just-
window guard.
You just said if, and that's what I have an issue with. I mean, the bottom line is that this was a regular apartment building, correct?
The regular apartment, yes.
Right, so this was not, a specialized, housing for incapacitated or, disabled persons.
That is correct, Your Honor,
Okay.
yes. But that doesn't mean that, if they're aware of the condition,
Well,
and
isn't
the
there evidence,
foreseeability
isn't
of
there
it.
evidence that notice told Argyrios, if I'm pronouncing that correctly, that gates weren't necessary on the windows?
Well, that's what the guardian did say.
Which wasn't controversial. Okay, let's hear from the other side, and you'll have rebuttal.
Thank you, Your Honors.
May it please the court, Dean Pillarella for defendant respondent. Turning first to the Brill.
Is there any evidence contradicting that notice told Argyrios that gates weren't necessary on the windows? Is there
No.
anything which puts that in issue?
No, there is not, Your Honor.
Why don't you address the Brill issue?
Yeah, so on the Brill issue. So the bottom line is the standard is was there an abuse of discretion? And here we had a proper cross motion under CPLR 2215 and Kershaw, okay, because we moved against the initially moving party. So then the only question becomes, as articulated by this court in the Galapa case that we cite, did our cross motion against plaintiff raise issues or causes of action that were nearly identical? I point out in the brief that the plaintiff actually abandoned this issue because he didn't argue that our motion wasn't nearly identical to his motion. He only argued it with respect to all Metro, and therefore he can't show that there was an abuse of discretion. But even if we get into that question,
You're
yeah.
saying that your motion was nearly identical to his motion for summary judgment?
Absolutely, both in terms of the cause of action and the arguments and grounds raised. So if we look at the cause of action question, if we look at the complaint, if we look at the BP, it's the same exact cause of action and it's the same exact theories of liability being asserted against my client as well as all Metro. If you look at the complaint, for example, at page 88, paragraph 13, both defendants are lumped together. Same thing for the supplemental BP, which starts at page 2474. So it's literally the same cause of action. It's the same theories. Plaintiff doesn't contest the cause of action point in his brief. Then if we go to the nearly identical issues or arguments, which we also meet, I argue in the brief that the gravamen of both motions really goes to duty and foreseeability, as my friend on the other side just argued. And in fact, even in plaintiff's brief, he tacitly concedes the relatedness of both motions because he argues, for example, at page 19 of his brief, he says there's a question of fact as to whether the appellant might fall, whether or not falling out of the window was a foreseeable risk. If you compare that with the plaintiff's initial motion against all Metro, starting at page 32 of his memo, these points were initially raised against all Metro. So the bottom line is, here the motion court was faced with a true cross motion that was patently meritorious, and it also concerned the identical causes of action, nearly identical issues and arguments that were raised in plaintiff's motion. And under that circumstance, the court exercised its broad discretion prudently.
If we do address the merits,
Yes.
why isn't there at least a disputed issue of fact as to whether or not any common law duty of care has been violated based on the particular circumstances of this case in failing to install window guards?
Yes, Your Honor, because the court dispositively dealt with that question in the Milano case, in which Justice Friedman was on the panel, as well as the Ramos case. The court dealt with common law in Milano, and it said, quote, defendants also had no duty under the common law to install window guards, since no evidence was presented that the window or ledge was in need of repair, And even if the window or ledge were viewed as a dangerous condition, the duty to eliminate the danger by installing guards or stops was imposed on the tenant, not the landlord, under the common law. So that refers to the panel referred to the Ramos case, which held accordingly. So any duty outside of the statutory duty, regulatory duty, would have been on the tenant. And one point that's important as well is plaintiff's argument puts the cart before the horse. The cases that the plaintiff primarily relies upon that deal with mental conditions that plaintiff claims stand for the proposition that we had to present evidence of his mental condition. As I point out in the brief, those all deal with hospitals, those deal with so-called halfway houses, okay, where there is a duty of supervision. There's no duty of supervision for a landlord-tenant relationship, irrespective of whether or not the plaintiff is mentally disabled. And just going to fundamental principles, as the court is aware, foreseeability doesn't determine the existence of a duty. It merely determines the scope of a duty once determined to exist. So the plaintiff's argument puts the cart before the horse because there is no duty. Finally, in the plaintiff's reply, he argues for the first time in reply that my client didn't provide an NYCAC 17123 notice. So not only
That's a new argument.
correct, it's raised for the first time in reply. And even if the court does get to it, if the court looks at 24 RCNY 12-13, the only thing, which is the appendix, which actually is the sample of the notice, the only thing that's to be informed is you have a right to window guards if there's someone under 10 years old in the building, which it's undisputed is not the case. So for those reasons, the court should affirm. Thank you, Your Honor.
May I, Your Honor?
Go ahead.
Your Honor, the counsel erroneously refers to the complaint with regard to the issues. That's not the law. The law in Brill and its progeny is you don't look to the complaint, you look to the original motion. So the issues have to be the same in the new motion and the original motion. Complaint is not considered. And as far as Brill is concerned, Your Honor, that's the gatekeeper. We don't get to the merits until the movant has either shown good cause for the delay or that the issues in the original motion are the same issues that the respondent is raising, the new movant. And they did not do that. I think we can accept the fact that they made no argument as far as good cause for the untimeliness of their motion. That's not anywhere to be found.
What about their statement that you didn't address the identical issue, that it was the identical issue in the original motion?
Well, the original motion, as I said, Your Honor, the original motion against All Metro talks about negligent supervision and a violation of All Metro's care plan. The issues regarding the estate are completely different. It has to do with window guards.
Thank you.
That was not raised.
Thank you very much.
Thank you very much, Your Honors.
HSBC Bank versus Aonsa.
Good afternoon, Your Honors. May it please the court, Sarahsaurus from Reed Smith, representing the plaintiff respondent. Briefly, Your Honors, just want to state a few facts here. Intervention was properly denied by the lower court. Intervention wasn't appropriate, first because the non-party appellant was on notice of the foreclosure by way of a notice of...
They waited around 4 or 5 years for the relief they're seeking here, right?
That is correct, Your Honors. They waited 5 years after they purchased the property. They purchased the property in 2019, December 2019, and didn't move.
7 years after the judgment of foreclosure and sale.
That is correct as
Very
well.
long time.
And any claim for personal jurisdiction is not applicable because this entity, that's only personal to the actual borrower.
That is also correct, Your Honor. And also notably, the non-answering, I guess the defendants, the borrowing defendants actually unsuccessfully tried to vacate the judgment and the default judgment and were unsuccessful and did not appeal that decision as well. Any claims that appellant is trying to make in terms of challenging the manner of the notice of the default judgment motion also fails because first, that was an argument that was never made by the actual person that was supposed to receive notice when they moved to vacate
And
the
counsel,
judgment.
it's fair to say that the appellant had notice of the judgment about 2 years or so before acquiring its interest, correct?
That is correct, yes, by way of moving to vacate that judgment. And also, appellate lacks personal knowledge as to whether or not they actually received notice, which, by the fact of moving to vacate that default and not raising that in their motion, shows that they never, that was never an issue on their end. And
Thank you, counsel. I think we get it.
thank you very much, Your Honors.
Yang versus Knights Genesis.
Good afternoon, Your Honors. May it please the court, Victor Tsai for the appellants. First off, I'd like to point out that the judgment, we're appealing the judgment of $10,179,000. First of all, I'd like to note that it double counts the judgment of 189 investors into the KG Bayside. As we all know, the KG Bayside assumed the loan, the so-called loan, from 1989 investors. So what happened was 1989 investors defaulted, and the plaintiffs got a judgment against them. The 1989 investors plaintiff was given an opportunity to loan whatever they invested in 1989 into KG Bayside. What happened was 1989.
Let's go to something more specific, because one of the issues before us now is a fraudulent conveyance claim.
Okay.
Why wasn't KB Bayside insolvent at the time the challenge transfers were made?
Well, the investors, the plaintiffs, intervener plaintiffs instead.
No, that's not my question. My question is about KB Bayside.
Right.
One of the questions we have to decide is whether KB Bayside was insolvent at the time it made the challenge transfers.
Okay.
So why wasn't KB Bayside insolvent?
All right. The KG Bayside was supposed to invest the money, or take the money that they have gotten as a loan from the plaintiff interveners and take the loan and put it into what they call, the property called 6118 Bayside Project. Right. So it was a loan agreement that they signed.
Counsel,
That's not
I
answering the
don't-
question, though, at all. You haven't answered the question.
They're not in. Your Honor, if I may, if they're not insolvent because it was a loan agreement, there has no equity inside.
Well, sir, on this record,
Right.
there was some information by Jianfei Chen.
Right.
Forgive me if I'm not pronouncing correctly.
Right.
Apparently, Katie Chen, his daughter, took money from KB Bayside and gave him money to which he used to buy an interest in 618 Bayside. And so the issue, that's part of the self-dealing here. That's part of the fraudulent conveyance that your friend is arguing took place here with Mr. Yan and Ms. Chen by taking roughly $3 million and not giving them back anything for it. So they have claims under the debtor-creditor law for fraudulent conveyance. Now, my colleague raises to you a question. In order to sustain a claim under the debtor-creditor law, you have to establish that the transferor, you folks that took the money, is insolvent, correct?
Right.
And in your briefing this issue, because you're the appellant, was KB Bayside insolvent?
No, Your Honor.
And the reason
No,
because
if we trace the money, the new money that came into KG Bayside was only $1.73 million. The rest was paper money from 1989 investors.
How much is 6118 Bayside worth?
There was a project that's worth about $24 million if it's finished to completion, At the time of the loan agreement, that appraisal was done, and these are sophisticated investors, Your Honor. They had the loan agreement, and they also have a pledge agreement. They could have acted on the pledge agreement, but they did not act upon the pledge agreement. If you trace the money, you see Jen Fei Chen actually trace the money. They put money back, or whatever, in excess into 6118 base.
Can I ask a question? Who owns, because there's just so many people here, 6118 Bayside? Who owns that?
KG Bayside owns 6118. It's in the tax returns. They are, I think, 60% equity owners.
All right.
So they have a pledge. They pledged that to.
Okay, I want to go further now. And that is approximately that value, like 29 million, right?
Something of that nature. yeah.
Okay,
If it's-
so on one column, we have, you say that it's KB Bayside that owns that company.
Right,
All right, well, the 25%.
right.
Then we also have, is it Jane Fed? And I know I'm mispronouncing the name, and I do apologize. But we also have testimony that he owns it. So wouldn't you say that's a conflict right there? We don't know who owns it. He says he owns it. You say another company. That's a conflict, right?
You know, if I made the translation could be in factor, but in the
Okay, stop. But you would agree with me, but there's some testimony that he owns it.
yeah, he says as shareholder. If the transcript says as shareholder, I don't know if because it's translation problem. It's on summary judgment.
So it's unclear.
It's unclear.
So if it's unclear, how can you get summary judgment if it's unclear?
I
Well, we know who owns it.
don't know, Your Honor.
Thank you.
Exactly.
Thank you very much. Let's hear from the other side.
Good afternoon, Your Honors. Glenn Lenahan, Oved and Oved LLP for respondents. I just need to clear a couple things up. Jianfei Chen testified unequivocally that he personally owns 25% of 6118 Bayside. He then identified several other shareholders who were all other individuals.
But isn't there a K-1 issued to KB Bayside by 6118 Bayside? Doesn't that reflect that KB Bayside is an owner?
Several things with that, Your Honor. First, that is attached to an affirmation that Jianfei Chen submitted in his own summary judgment motion, which is not on appeal here. That affirmation is entirely in English. There is no certification of a translator. He testified that he doesn't speak English. I don't understand English. I cannot read English. Under well-settled first...
Are you saying that the K-1 wasn't issued?
There's no evidence it was issued. For example,
We have the K-1 in the record. It's documentary evidence, and it says what it says. No matter what the affidavit says, the K-1 says that the company has a 25% interest. So why isn't that enough by itself to raise an issue of fact as to who really has that ownership?
So even if we ignore the admissibility facts and that it's not authenticated by whomever issued it, and that there's no evidence it was ever filed, there's no evidence it's legitimate, but putting that all aside, the loan agreements for KG Bayside define the borrower's equity interest in 6118 Bayside as what's set forth in Annex A. And that shows that at that time that they entered into these loan agreements in November and December of 2018 and January of 2019, KG Bayside purportedly already had a 60% interest in KG Bayside. My clients were investing money to get a greater
Doesn't that
interest.
just raise, doesn't that still, which is what I was trying to have your friend answer, doesn't that still raise an issue of fact, though, as to whether there really was insolvency in this case? Because whether there's an issue of whether they have a 25% interest or 60% interest, both of those, if they really, or it genuinely has an interest, would take it out of insolvency, theoretically.
No, I don't believe that's correct, Your Honor, because even if it did have an interest in 6118 Bayside, KG Bayside would have no right to use the assets of the LLC in which it was a member, if it was a member, to satisfy its debts to its investors. At the time that these funds were invested.
But that one of the elements, we're talking specifically about fraudulent conveyance here, right?
Yes, Your Honor.
So one of the elements of fraudulent conveyance is either that it was insolvent or that there was an injury because there aren't enough assets to satisfy it. So-
Yes, and they were not paid. That's not on appeal here.
Well, that's your breach of contract claim on your fifth and sixth causes of action, and
that's
again,
right.
to pierce the alter ego. But what's being emphasized here is the debtor creditor law, a key element is insolvency.
Under two
And you're,
I'm so sorry, excuse me,
and
Your Honor.
that's okay, but, and that's what we're grappling with here. In other words, can you, summary judgment, which means searching the record, on this record, has insolvency been established? So if you just analyze 25% interest in 6118 Bayside and say 60% and say it's worth 29 million, and you factor the appropriate percentage, that's almost $8 million, which means that would be enough to cover what's owed to you. I'm not getting caught up with the interest and all that.
Whatever the numbers are, I'm sure the math is right.
I mean, that's the issue.
Putting that all aside, it truly doesn't matter. A, there's no actual legitimate evidence that it's, as Mr. Sy said, if the project was fully developed, it would have been worth 20 whatever million. As of today, it's still a hole in the ground. In fact, Katie Chen
Well, the
misread.
real estate has value.
I'm sure it does, Your Honor, but KG Bayside does not own that real estate.
You have the burden of proof, because you're
Yes.
moving for summary judgment on the fraudulent conveyance. So you have the burden of proof, it's assuming there's an issue of fact as to whether the company really does or does not have an ownership interest, to establish that that ownership interest is insufficient to meet the debt. So they put forth this appraisal, which you're saying is incorrect because the building hasn't been built, but what have you put forth to satisfy your burden that the company actually is insolvent at this time, despite the fact that it allegedly has an interest?
The bank accounts at the time of the transfers, which was when
Right, but
insolvency
we're
is
talking
measured.
about the value of the building, whatever it is, developed or not being developed. You're saying that's not their appraisal is not accurate because the building hasn't been developed, but where's your appraisal that says this is the value of the property undeveloped?
The KG Bayside does not own the land, the building, or anything else. It only owns an interest in 6118 Bayside LLC, allegedly. They cannot use that ownership interest in 6118 Bayside to repay my clients. That could only happen if they own the entire thing and it was collapsed, or if the land, the deal, whatever it was transferred to KG Bayside.
That goes to your breach of contract claim.
No, respectfully, Your Honor, I think this goes directly to the insolvency claim because they could not repay the money by 2020 and January 2021 when it was due because they did not
Because
have.
they couldn't monetize it?
Could they have
They could, because is your argument that they couldn't monetize their interest in?
They could not. How could they have monetized an interest? They didn't even put forth an operating agreement for 6118
But if the
Bayside that
value
shows.
is there, would it be a fraudulent conveyance?
Yes, because the value is not there, is the point. If KG Bayside itself owned a $25 million piece of land, this would be a different conversation. KG Bayside does not own a piece of land or a building. It owns, allegedly, an interest in an LLC that owns other things. If I invest in your LLC, Your Honor, and Your Honor's LLC owns a...
And that interest is worth something, doesn't that contradict saying that there's been a fraudulent conveyance?
They haven't shown what that interest in 6118 Bayside
You keep
is
saying
worth.
they, but it's your burden, but thank you very much.
And I just would like to...
No, your time's up, thank you, thank you. You're over your time. And you didn't ask for rebuttal, so thank you. Barones versus 130 East 18 owners. Nobody wants to go first?
If it may please the court, Your Honors, Adam Frank for Appellant Respondent Unibud Restoration Corp. Your Honors, this is a labor law case involving an alleged fall through.
So, counsel, in one of the critical issues here, putting it separate from contractual indemnification, is who was responsible for the pipe scaffolding? It was Unibud, correct?
No, well, so
And
actually,
I'm being very careful. Let me finish my thought. There was bridge work, or sidewalk shed, depending, but we'll use bridge work because that's the term that was used throughout this record by Brenmack. And then you folk came in. You had the brickwork and the window work, and part of your responsibility in your contract was to put in pipe scaffolding. That's the term pipe, very different than bridge work.
Yes.
So you would agree those are two separate
I do, but I disagree with
components.
the designation of a pipe scaffolding because the term pipe scaffolding only came up because the plaintiff used it along with various other terms at his deposition. If you look at the deposition testimony from Interrenovation, who's the GC for the project, he actually testified there's no pipe scaffolding on this project. There was no scaffolding going up and down the building. What there was, in addition to the sidewalk shed that Brenmack put up, was a suspended scaffold that went up and down, but there was no set pipe
Who
scaffolding.
put that up?
The Unibud put up the suspended
Counsel,
scaffold.
one of the issues is what admissible testimony is there that's not hearsay, that this accident happened anywhere but on the scaffold. Whether you want to call it pipe scaffold or whether you want to call it something else, what evidence is there for this alternative theory that's being presented that the accident actually happened, on the sidewalk shed versus on the scaffolding?
Well,
That's admissible.
First of all, there's the plaintiff's testimony himself.
The plaintiff consistently testified that this accident happened on the pipe scaffold, which you said doesn't exist, but that was plaintiff's testimony, that that's where the accident occurred clearly.
Respectfully, Your Honor, I disagree, and the court, in the lower court, actually pointed out that the plaintiff used various terms interchangeably, and that was one of the bases for why the court denied the indemnity motions in the lower court. We believe that same question of fact as to where the accident happened and that the fact that the plaintiff used various terms interchangeably should also have been applied to plaintiff's motion for summary judgment because it creates a question of fact as to where the accident happened and how the accident.
Plaintiff's testimony was that he was on the scaffold,
No,
that he went on the plastic part of it, whether or not that was part of the scaffold, and he fell through. That was plaintiff's testimony.
He testified that that morning he worked on the suspended scaffold for a period of time. He then was very clear that he left the suspended scaffold and went to work in a different area of the job site. That different area of the job site was the sidewalk shed. And that is also...
That's not plaintiff's testimony. I mean, you might want it to be, but
Well, his
tell me where
testimony
that
was
plaintiff...
unclear.
Tell me, you keep saying it was plaintiff's testimony. Where in the record can I look and see that plaintiff describes being on the sidewalk shed versus a pipe scaffold?
He used the terms interchangeably: sidewalk shed, pipe scaffolding, sidewalk bridge. He described the apparatus he was on as made of wood and pipes and metals with handrails. That describes the pictures that plaintiff produced of the sidewalk shed in question, the sidewalk bridge that was put up by Brenmack. Plaintiff produced a photograph, and even though he did not identify in that photograph where his accident happened.
So that's your... Go ahead.
Defendant didn't testify that he didn't perform any work that day while standing on the sidewalk bridge. Doesn't the record at pages 155 to 156, at 338 and 368 support that he said he never performed any work that day while standing on the sidewalk bridge?
Yes, but again, he testified that he left the suspended scaffold. Mr. Gemelti from Inter testified the only two apparatuses present were the suspended scaffold and the sidewalk bridge. There was no other apparatuses present there. So plaintiff's testimony was very clear. He left the suspended scaffold and he took, I believe he said, 15 to 20 steps away from the suspended scaffold to go work in a new area. If there were no other apparatuses available, reasonality would say that he was on the sidewalk bridge at the time of his accident, which is also supported by other evidence in the record.
Didn't Mr. Gemelti refer to Mr. Gutierrez, which was your foreperson on the job?
Yes.
Who went and helped?
Well, actually, the testimony was Mr. Gutierrez was an employee.
Right. Didn't he help the plaintiff after he fell? So
Yes,
he was
and
there.
Mr. Gutierrez
And he
testified.
doesn't refer to sidewalk shed. He refers to that particular, your suspended scaffolding that you were
No,
worked on.
respectfully, Mr. Gutierrez's Mr. Gemelti's testimony about what Mr. Gutierrez told him.
Told
is that
him.
He tripped and fell while walking on the
That sounds
sidewalk.
like the hearsay testimony. Thank you.
Thank you.
May it please the court, Valerie Presenter for Respondent Appellants 130 East 18 Owner Corp. And Inter Renovations. I would like to discuss the third-party claims in this case with respect to Unibud. So the subcontract agreement writer in this case specifically says that its terms and conditions shall supersede and govern any inconsistent term found in other parts of the written agreement. That subcontract agreement writer at paragraph 1 specifically said that Unibud is to defend and indemnify the owner, which is 130 East 18 owners, and Inter for all claims arising out of or resulting from the work.
Very
The second
broad
indemnity
indemnification
provision, which
clause,
was
yeah.
Aonsa.
It's a very broad indemnification clause. It doesn't require negligence. And you're saying the broader one trumps the narrower one.
Yes.
You don't have to show negligence. But two questions come up. One that comes up is you have to get unconditional, you have to be free from negligence, which is another issue. I know that's part of the appeal. And there's also the issue of if it didn't occur on the pipe scaffolding or something set up by Unibud, that would also prevent the indemnification. So do you want to address those two issues?
Yes, so first in terms of if it didn't happen on the pipe scaffold, he was a Unibud employee. Therefore, he was in the course of performing work that the contract addressed. So it doesn't matter
Well,
whether.
that goes to the indemnification. Okay, so you're saying it doesn't matter where it happened because it's still work that he was doing.
Exactly. And in terms of the second part of it, which also ties in with the portions of our.
And in addition, that you had nothing to do with his work except as your general contractor role, but you weren't supervising his work or directing his work.
Your Honor literally just went straight into my next argument with respect to the 200 and the common law claims, which are intertwined with it. Because
It's intertwined with the indemnification.
yes, in terms of the fact that there is no evidence that this could have been caused by the sole negligence of the owners and Inter, because we had one person, Gementi, who was assigned, and he periodically only went to the site. He only went there to view the progress of the work. There was no notice of any defective condition of this black piece of plastic that supposedly was involved in this. So at the end of the day, with that respect, it doesn't matter whether it happened on a hanging scaffold, whether it happened on the sidewalk bridge. Plaintiff was in the course of his employment for Unibud, and therefore we're entitled to recover on our third-party claims against Unibud. I do want to just quickly address the opposition to Brenmec's own motion, because as the court within its own order found that there's issues of fact whether it happened on the sidewalk bridge versus the hanging scaffold. If there is such an issue of fact, then they cannot be let out of their duties.
No, they only can win if we find there's no issue of fact as to where the accident occurred, or no admissible evidence that it occurred anywhere other than on the scaffold.
I'm sorry,
The only way we could let them out is if we found there's no issue of fact and that it occurred on the scaffold and not the sidewalk.
exactly, and since
Which is
the
one of the
order-
issues we have to decide on this.
Exactly, and if there's no other questions, thank you very much.
You have a question?
No, it's okay.
Okay, thank you.
Thank you.
You're not an appellant though, right?
No, that's.
Should all the appellants go
I'm just a
first?
respondent. if-
Right, so you go next.
I'm just
Yeah.
following court.
Jonathan Nuejo for Respondent Appellant Brenmack. There is no question that the plaintiff's testimony, and it's the only admissible evidence in this case, that occurred, he said it occurred on the pipe scaffold.
Okay, well, what
Actually,
about
he-
the argument that there is no such thing as a pipe scaffold? There's the hanging scaffold and there's a sidewalk shed, and there is no
Actually-
pipe scaffold in this case, and there's testimony to support that.
That's not true. Specifically, the Brenmack's owner testified that they put up a landing platform for the hanging scaffold, which was consistent with the plaintiff's testimony that he gets off the hanging scaffold onto a platform that they're landing the hanging scaffold on.
You're saying that landing is not a sidewalk shed, it's a.
It's not the,
third thing.
he specifically says it's not the sidewalk shed. It's, the sidewalk shed only goes around 3 sides of the building, He's working at the back of the building.
Where there was no sidewalk shed.
Yes. Well, actually, at some time, there was a sidewalk shed, but he wasn't aware of it. And in fact, that sidewalk shed was 8 feet above the courtyard. And this landing platform was about 3 or 4 feet higher than the edge of the back of the sidewalk shed on the side of the building. That's 20 feet above the courtyard, according to the plans. So now he's something like 25 feet above the courtyard. He obviously couldn't
Falls
step.
in a gap between the scaffold and the building?
I beg your pardon?
He falls in a gap between the scaffold and the building?
Apparently,
Which is
yeah.
covered by plastic?
That's according
And
to
there's
his
nothing
testimony.
underneath the
yes.
plastic?
Yes, it's just a platform that they put up so that they could land hanging scaffolds.
When you say put up, it's unibut.
Unibut, yes.
And certainly not Brenmac.
Definitely not. The only thing we did
That's
on
your
this.
position.
Yes, the only thing and that's supported by all the evidence in the case. The only thing that Brenmac put up was the sidewalk bridge, which went around 3 sides of the building, and a separate section at the back of the building, which was 8 feet off the ground. Obviously, plaintiff couldn't step from the landing platform at 25 feet onto the 8-foot sidewalk bridge at the back of the building. So the only way this entire story makes sense, at least from the plaintiff's perspective, is that he comes onto the sidewalk bridge, walks down the side of the building, steps up onto this landing platform, which is where he says his accident happened. And that's all. The landing platform and the hanging scaffold
Thank you.
is not Brenmac.
May it please the court, John Shore for plaintiff respondent. Just a few things, Your Honors. There is nothing in the record, as the lower court noted, to controvert that my client was caused to fall from an unprotected opening. Everything they produced was hearsay. The testimony of Mr. Gemelti, what Mr. Gutierrez allegedly told them, is pure hearsay. The testimony of what Mr. Zagroba alleged, that what Mr. Gutierrez allegedly told him, is hearsay. And then with respect to the Elmhurst Hospital record, it fails on 3 counts. And many of this panel has been on many of these cases, and I know everyone on this panel is very
So
familiar.
essentially, you're saying that you've met your burden and they didn't counter your burden on 241.
Absolutely. Unless this court has any questions for me, I'll rest on my brief.
Thank you.
Thank you.
Thank you all. People versus Hernandez. Oh, go ahead. Sorry, introduce yourself.
Good afternoon, Allison Haupt on behalf of Mr. Hernandez. Respondent concedes that the grounds on which the lower court denied Mr. Hernandez's motion were wrong.
Is there any issue before us other than that whether or not it should be remanded for youthful sentence determination?
No.
That's the issue, right?
The issue, correct.
I was just surprised how much time you asked for because it doesn't seem like that complicated. That's why I'm trying to understand if there was another issue involved because we routinely remand for youthful sentence determinations when they're not made because the law is pretty clear around that area. So that's your argument, that we should remand it because the court never made the determination and it needs to be made, right?
Exactly.
So we've already decided this on direct appeal. You weren't required to raise this issue on direct appeal?
No, Your Honor, and respondent concedes that there was no obligation to raise this on direct appeal because a Rudolph and a Middlebrooks claim implicates the legality of the sentence. People versus Drummond is a Court of Appeals case that makes that quite clear. So much precedent. People versus Perez, People versus Smith, all the cases in this court. And that when it implicates the legality of the sentence, it can be raised by 440-20 motion. There's no procedural bar in 440-20, and it says that at any time after entry of judgment, if the claim implicates the legality of the sentence, it can be raised by 440-20 motion. And that's not in dispute here. Respondent agrees that Rudolph and Middlebrook's claims implicate the legality of the sentence, not the conviction, that it can be raised by 440-20 so long as the sentence was not final at the time that Rudolph and Middlebrooks were decided. And of course, they agree that Mr. Hernandez's sentence was not final.
And it's your position that there has to be a specific finding, even as to the mitigation factors on an armed felony?
Well, Middlebrooks makes that
Because
clear.
my question is, why couldn't what the trial court said at the time of sentencing be regarded as the court's finding about youthful offender?
Well, the precedent makes clear that it needs to be an explicit determination. And when it comes to this question of whether or not someone's an eligible youth, what Middlebrook says is if the court determines that neither of the 720-10-3 factors exists and states the reasons for that determination on the record, then no further determination is required. So Middlebrooks makes clear that you need to grapple with those factors and you need to put on the record why those factors do not apply. And that did not happen here.
So I'm just curious because I'm picking up on what my colleague asked you a minute ago. If they agree, why are we here? Why wasn't this withdrawn and you just set up a hearing date?
Well, they agree that Vanderhorst was wrong and that the grounds on which the lower court denied the motion was wrong because, of course, Mr. Hernandez could raise this claim by 440-20 motion. I think there is a dispute as to the substantive issue here. I'll leave that to respondent, but there shouldn't
You
be
mean
one.
as to whether what the court said sufficed for a finding on the YO?
Right.
Because the court says with regard to the drugs, there may be an ascending approach by the justice system starting with YO. So the judge does make reference to YO and then go on to say, but when you discharge a weapon at people, a loaded operable firearm and discharge it at people, you have made the big time one time right away.
So reference is not an explicit determination on the record, and this court has held that in numerous cases. We cite to that in our briefs, that even if you get a sense of where the court is going, if the court expresses skepticism, that's not an explicit determination, and it's certainly not what Middlebrooks requires when it comes to eligible youth. And I just want to point out that that's what's at issue here, the determination of whether or not he was an eligible youth, because that's what respondent argued below. They argued that a determination was made and denied as to eligibility. They make different arguments here on appeal. That's wildly unpreserved, and their arguments are now in complete contradiction to what was argued below. And the record makes clear that to the extent that there's a conversation being had on the record, it's about eligibility. And no explicit determination was made, no review of the factors. They didn't state exactly what Middlebrooks requires, which is why what the court should have done was order resentencing in this case. And so, one, the court should clarify that Vanderhorst is not good law, because even though respondent agrees before this court that these claims implicate the legality of the sentence, they vigorously argued below that Vanderhorst had to be applied in the absence of precedent from this court.
But we have a precedent right now that even addressed the equivocation of what the court did with People versus Cummings, which was just issued this past February.
Right.
Which specific language says here, although it is apparent from the record of the plea proceeding that the court did not believe the defendant was entitled to youthful offender treatment, it did not make the requisite explicit determination. That's exactly what's being argued here, right?
Exactly.
So this precedent really requires a remand.
It requires a remand, and it also requires clarification that Vanderhorst is not the rule of this court. That 440-20...
That is clarification.
I'm sorry?
Anyway, I think that is clarification.
But that's on the separate point of here, when a case where the sentencing was before Rudolph, but the case was not final at the time, that you can, in fact, bring a 440-20 motion challenging the legality of the sentence when it's a Rudolph or Middlebrooks claim. Respondent argued that Vanderhorst prevented a 440-20 motion in that scenario, and that's what's so important for this court to clarify.
That's not what he's arguing now, right?
He's conceding that
Right,
Vanderhorst
so
is
we
wrong.
wouldn't decide it because he's conceding it. Then you want us to make a, it doesn't matter. You want us to make a point of a law that he's not arguing here, which we wouldn't do because that would be an advisory opinion.
But it would need to be done because that's the basis for the denial. The lower court held that Vanderhorst needed to be applied, and so
Thank
it's
you.
necessary. Thank you.
See, you used the whole 6 minutes as it turned out.
Good afternoon, Your Honors. Hunter Barron for the people. I did want to start on the question of whether the court made a YO determination, the Rudolph determination. I think to start, the most on-point case here is People v. Parafetti, where the court said, given the seriousness of the conduct, the multiplicity of the crimes, a youthful under sentence is out of the question. That is substantively the same as what the court in this case said, which I think is best characterized as there are some situations like drug crimes where YO may be appropriate, but it was absolutely not appropriate in this case because...
Counsel, where is the explicit determination on the record that's clearly required under the law?
Well, I think the explicit...
The judge certainly talks about it, but you need to have an
Absolutely.
explicit determination. I don't see where that is in the record.
Well, I think explicit determination is different from precise language determination. There's nothing in Rudolph that requires a court to say certain magic words. I think all that needs to be clear is that the court is making...
Right, but as I started by saying, we've remanded so many cases already at this point because the explicit words were not used. This is my determination. I am denying or I am granting a useful sentence status.
Well, Your Honor,
I don't see where that is on this particular record where there's an explicit determination that it's being denied.
I would agree with Your Honor that this court has remanded a lot of cases. I think most of those cases are cases where the court said nothing at all about YO or the defense attorney didn't request it at all.
I think that's true. I think it's where there's not an explicit determination.
Well, Your Honor, I think just to pick up on some of those cases...
Even though it's clear that that's what on many of the cases that I would call, it's clear that that's what the judge was going to do. There's no question that's what the judge is going to do, but the judge didn't say it explicitly.
Sure.
Are you saying that that my colleague read to you that one time you can go big time and you would not be eligible for youthful offender? Do you think that's explicit enough for the listener?
Yes, Your Honor. Even though I wouldn't read it in isolation, I would read in the whole context of the hearing as well. Before this hearing, there was a written request for a YO determination. It was extensively argued. The prosecutor opposed it. The defense attorney talked about how it was merited. And at the end, the court gave this determination that mentioned YO specifically. And I think that's more than enough. I did want to pick up on what Your Honor, Justice Kern, was talking about, those cases where it wasn't an explicit determination. People v. Bannister was a situation where a court made an express determination for one conviction, but didn't address a separate conviction. And that was a case where I think, even though it was clear that YO wasn't going to be granted, he didn't make either a global determination or address those convictions separately. Another example is Bassano, where it's not clear from the decision itself, and these cases are cited in the appellant's brief.
Why is this case not akin with People v. Cummings, which we just issued, which also has a judge saying something like what this judge said in the context of, well, I don't think you're really worth this type of status?
I think, Your Honor, I'll admit I'm not aware of the particular facts of that case, but I think here it's more than enough because of the explicit mention of YO and saying that basically that it wasn't warranted in this case. And I did want to address the Middlebrooks issue. There is a department split on this, and ultimately, if this court reaches the Rudolph determination, there's no need to remand for a Middlebrooks determination because ultimately the question is moot, and that is what the Fourth Department has found. And that's ultimately the right approach here because the whole point of Middlebrooks is to make sure that every defendant who is possibly eligible for a YO determination is ultimately given that chance at a sentencing hearing, and the defendant absolutely had that chance here, and the court made that determination.
I mean, is there or isn't there a need to specifically address the mitigation factor possibility.
Right. There's no, under the Fourth Department approach, which I think is more in the spirit of what Middlebrooks is addressing, there's no need to address the whether the mitigating factors of the eligible youth determination are present, because ultimately it was clear here that the court was making a Rudolph determination because they talked about the seriousness of the offense.
You know, counsel.
The mitigation argued here?
Yes, earlier. The mitigation argument was that the defendant was a minor participant in the events. That was a very distinct argument and not ultimately what the court addressed in the final determination.
You say that the court mentioned YO, and that's true, but let's look at the context in which it was mentioned, because, you know, the court stated, right, that with regard to drugs, there may be an ascending approach by the justice system, starting with YO, probation, a split sentence, a short prison term, etc. But when you pick up a loaded, operable firearm and discharge it at people, you have made the big time one time right away. So yes, mentioned YO once, but was there any other discussion about, you know, YO is not appropriate, any other discussion about, you know, in general about YO, or just that one thing about YO?
One thing in that particular section of the court's decision, but that was at the end of the entire sentencing hearing, much of which was addressed first toward the mitigating factor of the minor, whether defendant's role was minor, and then directly after that discussion, the defense attorney discussed why the defendant's conduct was not particularly serious or mitigating in this case. Yes, thank you.
I'll just pick up where you started, which was to say that you've remanded for this all the time. There was no explicit determination here. And so this can be raised by 44020 and should be remanded for resentencing.
Thank you.
Thank you.
Sarahsaurus Investors versus B2C Alternative Equity.
Good afternoon. Brian Fisher, Jenner & Block LLP for the appellant's defendants. May it please the court. We've appealed because plaintiff's complaint seeks enforcement of a non-existent sales contract.
Well, didn't the trade confirmation identify the parties, have a specific asset, and it was executed by the parties and the guarantor, Mr. Charnas? True?
That's all correct, Your Honor.
Okay.
But
so why shouldn't that be deemed a contract?
Because the agreement that the plaintiffs allege required the transaction is called an assignment of claim that was never executed. And the trade confirmation that Your Honor is citing from says that the parties, both my clients and my opposing counsel's clients, retained sole and absolute discretion over the decision.
One of the issues in these type of cases with a trade confirmation like this is whether it's an agreement to agree, obviously, or just negotiation. And one of the other big questions is whether that should be decided on a motion to dismiss versus a summary judgment. And you've chosen here to make a motion to dismiss rather than a summary judgment. But my question is, under the full panoply of circumstances in this case, which includes an executed writing, which memorializes agreement, and includes language that this is a binding agreement, which are a lot of the factors that were considered in Seaport Global, which is a case that addresses this. I know this is a long question. Why, under the circumstances of this particular case, shouldn't we defer that determination to a summary judgment motion rather than a motion to dismiss?
Because from the four corners of the trade confirmation, we see that the parties did not evince an intent to be forever bound to enter into the assignment of claim, which is the agreement being sued on.
It says, though, first of all, it's executed. Unlike many of the cases that you cite, this is an executed agreement. Unlike many of the other cases you cite, it says it's a binding agreement. And unlike many of the other cases you cite, it has all the relevant terms. So even though it does say it's subject to an assignment agreement, everything is there, and it clearly imposes some obligation on the parties to to continue to negotiate in good faith. So why under those circumstances, again, shouldn't we hold off on that determination?
We agree, Your Honor, that it does impose upon the parties an obligation to negotiate in good faith, but in the binding effect language that Your Honor just cited, I think we need to read the entire provision, the entire sentence. In the same exact sentence, before even a period, it says, "This confirmation shall constitute a binding agreement among the parties, provided that any party may terminate the confirmation at any time it's not satisfied with the form of assignment of claim or any transaction documents
Right, but
contemplated."
here there was no negotiations. This was not a case, or it does not appear from the record that this is a case where the parties engaged in good faith negotiations, tried to come to terms, couldn't come to terms, and therefore it ended. There's strong evidence in the record that one side, your client, obviously, was not negotiating in good faith and was never really was agreeing to come to terms, and that's supported by the fact that there was a price change during this, which would support their not wanting to go forward. So why don't all of those raise issues that's more appropriately decided on a summary judgment? Because again, this wasn't a case where agreement went back and forth, language went back and forth, and there's a breakdown in negotiation.
I just want to be clear.
You were reading the agreement, but you didn't finish the last several words, which following a good faith negotiation with the other parties.
Absolutely, Your Honor, and I was doing that in the interest of time, but I will say that even under Goodstein, where bad faith negotiating behavior was alleged, and even under Garda, which was a case that Your Honor was on in 2021, and we cite lots of authority, if there was dishonorable conduct, and again, these are all allegations, there's no evidence yet.
It's a motion to dismiss. That's why I keep asking why this shouldn't be
Because
decided on
under
summary
Goodstein 2, we know that the outer limit of what may be recovered by a plaintiff that has been claiming, in truth, a violation of an agreement to negotiate in good faith is out-of-pocket costs, which are not alleged here. Instead, all of the relief sought by the plaintiffs here assumes entry into an assignment of claim, which all parties, my clients, my friends' clients,
Well, this is
retain
a
the right not
damages-
to enter into.
It's the same question that I have since you're getting into damages. Normally, we don't decide the appropriate measures of damages on a motion to dismiss. That's something that's left for a summary judgment motion. And that this seems to be, you seem to be gearing up towards your argument that because there's no damages, we shouldn't let this case go forward. But again, why shouldn't we decide that on a summary judgment motion rather than a motion?
Your Honor, I understand that we're not going to see tons of cases in which damages decisions are decided on a motion to dismiss, but we do cite authority,
And we have
including trade
cases
and
that
industry.
say that,
Trade and
we
industry.
should decide that on a summary judgment rather than a motion to dismiss.
We do have examples since Goodstein 2, including trade and industry, which is an opinion of this court, in which a damages determination is made under Goodstein 2. We have it's from the Southern District of New York case that we cite as well, where the court opined that there's no limiting principle in Goodstein 2 that cabins it to summary judgment. If we have a complaint that is so obviously treating the world as though the assignment of claim was entered into, which they admit it wasn't, and then breach, and then seeking recovery on
You're
that.
sort of asking us to decide what the scope of the agreement was initially, which is, again, if that has to be deferred for summary judgment, it seems like we should also be deferring the damage issue to summary judgment.
But as far as the scope of the agreement goes, it says on the face of the trade confirmation that it's not just subject to in the Seaport Global way, but it goes on to say that the assignment of claim needs to be acceptable to the buyers and the sellers in their sole and absolute discretion.
Right, once it's good faith negotiation.
Yeah, I was just, does it say it's a binding agreement?
It does say it's a binding agreement. It doesn't say to buy and sell a claim. I agree that this trade confirmation is a binding agreement, just as there's, like in Goodstein, for example, a binding agreement to negotiate. And it's clear from the four corners of the document that the parties are bound to do no more than negotiate because they're allowed to terminate the negotiations and they're not forced to sign an
Isn't there an issue here
assignment
whether
of claim.
they in fact did negotiate?
I'm sorry, say that again?
Isn't there an issue here whether in fact there was negotiation?
I would respectfully disagree. I don't think that there can be any level of bad faith, there can be any level of
The
recalcitrance
agreement
that
does
takes
call
you
for
out
good
of the...
faith negotiations.
I'm sorry?
The agreement does call for good faith negotiations.
It does, but Goodstein 2 says that the penalty, or the remedy, I should say, for breach of a duty to negotiate in good faith is not conflating the agreement that the parties were working toward into the preliminary agreement and then giving relief on that aspirational agreement, but rather out-of-pocket damages.
Thank you.
Good afternoon, Your Honors. Martin Eisenberg, attorney for the respondent appellant. Every case cited by the defendants in their brief was decided on summary judgment, not on a motion to dismiss. And in fact, the defendant's principal reliance case, Goodstein, which is what the defendants are hanging their hat on, was decided on a motion for summary judgment after a motion to dismiss was denied. So this is exactly the same situation. The same arguments were made in Goodstein, which, by the way, has much better facts than the facts of this case. And even under the Goodstein case, the court said, you know what, it is premature to make all these decisions regarding the scope of the agreement, the amount of damages that are necessitated by a breach on a motion to dismiss. And why is that? The reason for that is, on a motion to dismiss, every allegation in the complaint is deemed to be true. And here, the allegations of the complaint are very clear and they're very precise. Not only did the defendant negotiate in bad faith, but if you look at the trade confirmation has specific pre-negotiated terms that the defendants explicitly agreed to include in the assignment of claim.
Which leads me to a separate question, since it's the subject of your cross appeal.
Yes.
Which is the constructive trust and also actually the unjust enrichment.
Yeah.
We do have an agreement here, and it's a clear agreement.
Right.
So first of all, why doesn't that knock out the unjust enrichment?
It does not knock out the unjust enrichment because there are two grounds under which an unjust
And the constructive trust claim, actually.
yeah.
And the constructive.
Right. I'll address the unjust enrichment first, because the unjust enrichment it relates to the constructive trust.
What's unjust here? Other than the fact that potentially the contract was breached, if there is an enforceable contract, what is it?
Well,
an unjust enrichment
a claim for unjust enrichment can be pleaded in the alternative if a contract is not found, but it can also be pled.
But here there's clearly a contract.
No, yes, even if a contract is found where the scope of the terms and the obligations of the parties are in dispute, then an unjust enrichment claim could be asserted. And the cases are cited in my brief, and in fact, I think Judge Barak cited the case. Here, there's a question as to—
Counsel, isn't there a large number of cases which hold, in circumstances similar to this case, that when there is a clear agreement of the type of this that's present in this case, you can't go forward on an unjust enrichment claim. It is barred by the existence of the written agreement, particularly one. It's all the reasons why it supports you going forward on the contract claim, because there is a clear agreement. It says it's a binding agreement. It's signed by both parties. All of those undercut allow me to go forward on an unjust enrichment.
The reason why we feel differently, Your Honor, is that it's not just whether there's a binding agreement. It is an unjust enrichment claim, and the cases from the First Department say this. An unjust enrichment claim can be pled if there is a dispute regarding the scope of the contract.
Okay, but let's say there's no enforceable contract. Then why should you recover? The only real reason why you have a basis for recovering in this case is because you thought you entered into a valid contract and that contract gave you some rights. If it turns out, ultimately, that there is no valid contract, then why are you entitled to recover?
Well, I mean, you always plead, you can always plead.
You always plead it, but there's a lot of rules about quasi-contract claims not being allowed to go forward in the alternative when the real claim being asserted is a contract claim.
Right, but if a contract isn't found, then you could make an argument that there were promises made and based upon—
There isn't really an issue here about whether a contract's being found. There's no question there is a contract. The question is whether the contract was lived up to, whether there was the good faith negotiations that were called for by the contract. It's not a question of whether there's—
He's making an allegation that the contract was merely an agreement to agree, and that the only obligation on the part of the parties was to negotiate in good faith.
So then we would have to agree with that before we would get to an unjust enrichment.
Well, I mean, it's an alternative pleading. He's making an assertion that may be true, Your Honor, but that has to all be determined.
No, if we agree with that, arguably,
record.
if we agree with that, arguably, there's no claim, because again, you're not allowed to go, there's a very well established black letter law. You can't go forward with a quasi-contract claim when there's a clear agreement. Whether or not it's an enforceable agreement is not the test, it's whether there's an agreement.
But he's contesting that there's an agreement.
Counselor, I have another question.
Sure.
You know, how are the plaintiffs entitled to the imposition of a constructive trust? There's no confidential or fiduciary relationship.
There is not. That is correct.
Oh, okay.
All right.
So that's bye-bye.
No, my understanding of the law is that those are only guidelines and that the predominant reason to impose a constructive trust if there is an unjust enrichment. And we believe that there is unjust enrichment here because, as I stated in my brief, this looks like B2C Alternative Equity, which is the claim holder in this case, looks like it's a special purpose vehicle, which is solely owned and controlled by one entity. And the concern is that they still hold the claim because they reneged on the sale. The concern here is that if the bankruptcy distributions on account of the claim are distributed to B2C Alternative Equity, those assets, those funds will.
So what did the plaintiffs, transfer to the defendants in, reliance of any promise? What did they transfer?
The transfer is the bankruptcy distributions which my client was supposed to get. Those distributions are in the hands of the defendants.
I'm going to let you expand that further on
sorry?
On rebuttal. I'm going to let you expand that because you have 3 minutes for rebuttal. I'm going to let you expand on that further in rebuttal.
Thank you.
You can focus on your constructive trust claim.
I know the procedural posture is important. Mr. Eisenberg started by saying we have no motion to dismiss cases. It's just flatly untrue. We wouldn't be here if we had no motion to dismiss cases. Trade and Industry Corporation from 1995, and I quote, this is a motion to dismiss case where it knocked out an attempt to get lost profits damages akin to what's being sought here because there was a mere agreement to negotiate. It says that we cannot allow those damages to proceed where the plaintiffs were attempting to elevate mere negotiation to the status of contractual obligations despite obvious indications that the parties did not intend to be bound and failed to achieve meeting of the minds. And we have other motion to dismiss cases cited clearly in our papers, and we announce it as such. Here, not only is this merely an agreement to agree, but the trade confirmation itself, yes, it does have some detail, but it doesn't have all the material detail that's needed to require then the parties to perform an assignment of claim. And the way that we know that, we focus on the recourse provision in our papers, that there could be many recourse provisions. All that this document says is the parties retain sole and absolute discretion over an assignment of claim that will contain indemnities, recourse.
Thank you. We'll carefully review the agreement.
Thank you, Your Honor.
Obviously,
Thank you.
Why don't you finish up with the constructive trust, since you were getting deeply involved in that.
Thank you. So it is to prevent injustice. So, I mean, I cited the Simons case. It's a Court of Appeals case in which, in that case, a husband was supposed to name his wife as a beneficiary.
But the hallmarks of a constructive trust is confidential fiduciary relationship, as my colleague stated,
that is
and
true.
a reliance on a promise made. So I don't know how you fit into either of those categories in this case.
Well, I'm going to turn to the Simons case, which is a Court of Appeals case. In that case, the reason why constructive trust was imposed was because of the futility of obtaining a judgment against the defendant in the case, because the defendant was insolvent. The husband's estate was insolvent. The husband was supposed to name the first wife as a beneficiary in a life insurance policy. Instead, he named his second wife after he died, and the funds were in the hands of the second wife.
Sounds like an attachment claim rather than a constructive trust claim. I mean, because a constructive trust is when it's really reserved for those situations where there's some confidential relationship, fiduciary relationship, none of which are at all alleged here. It sounds like you're looking for a prejudgment attachment. Not that
we're not looking for a prejudgment attachment.
That's what it sounds like you're describing.
I can see that all of the elements are not met, but I guess what I'm banking on here is the unjust enrichment and the gross injustice in somebody being able to get out of a situation where they promise to sell a claim, they get $20-30 million of distribution proceeds, which were supposed to go to my client, and we're alleging that they did this in bad faith because the market price went up, and then those funds are just going to dissipate and will have no remedy, which is what happened in Simons, where the court said, listen, you don't have a remedy against against the party, so we're going to impose a constructive trust so that we prevent what could be a gross injustice. And my last point on this would be, again, our position would be that all these issues
Is it
are...
fair to say if there's no unjust enrichment, there's no constructive trust here?
I wouldn't say that. I don't necessarily, it might be. I'm going to back off on that. It might be, but the question is, was there an unjust enrichment? Should there be constructive trust? This is too premature. Let's get a full record here. Let's find out exactly what went on before we jump to conclusions and strike out claims when the facts of this case may demonstrate that we had a really bad actor here. We don't know this, but this is what we're alleging. But until we get a full record, let's not knock these claims out. Give us a chance. Give us a chance to prove our case. We make some very serious allegations, which we believe are true. Give us a chance to prove our case before knocking us out of the box at this stage. Thank you.
Thank you very much. And our last case on the calendar, PanWest NCA2 versus Rockland NCA2.
Good afternoon, Your Honors, and may it please the court.
Oh, I'm sorry. I didn't realize. Let me start you again.
Are you arguing? Are you arguing?
Okay.
Good afternoon, Your Honors, and may it please the court. I'm Josh Katz for the appellant respondent Rockland NCA2 Holdings. In reading the briefs while I was waiting downstairs not very long, one thing that I kept occurring to me is I couldn't tell which side was asking for summary judgment and which side was opposing it.
Well, your focus here is you feel the court was wrong in granting your friend or the other side summary judgment on liability on the NAM.
That's one issue, and then...
And as to the latter, the pond claim, the court found everything an issue of fact, so you're really challenging the first
The
part.
other side's saying that
That's
they
true.
should get summary judgment.
I honestly don't think any of us can say for certain what exactly the
Counsel,
Supreme Court Justice did on the
issue,
pond.
which is very clear, is is the other side, the buyer, entitled to summary judgment on both claims? And they're separate analysis, but are they entitled to summary judgment on the NAM claim? Are they entitled to summary judgment on the pond remediation? And if they are, is it for some certain, should there be a remand for a determination of damages on both claims? So why don't we start with the NAM claim and whether or not they're entitled to summary judgment on liability on that claim, and why aren't they entitled to summary judgment? Because one of the obligations under the agreement is to afford reasonable access to the plaintiff for the books and records of the company, and arguably as a matter of law, by failing to disclose the NAM cost to plaintiff before the closing, there was not full disclosure of those books and records. So why isn't that enough by itself to grant summary judgment to plaintiff on the NAM costs?
Because, well, I think it's important for this court not to, fall into the same trap that I think the Supreme Court Justice did, which is to focus on the actual maintenance issues themselves. There's no issue in this case that the underlying maintenance was hidden from them. We made no promises about the maintenance. There's a spreadsheet.
Right, but I'm not, the issue though that you argued below, I think very strongly, is that wasn't necessarily a breach of the contract because there was no obligation. So that's why my question was very focused in that why isn't it a breach of the provision in the agreement that you were required, or your client was required to afford reasonable access to the books and records. So why wasn't the failure to disclose the NAM costs, why wasn't that a breach of that specific obligation to provide access to the books and the records?
At least two reasons. They required reasonable access. When you look at the emails, they get an email at 7:30 at night saying, hey, what's up with these NAM costs? A young associate writes back and gives the wrong answer for an honest reason. They came into this case claiming all those sorts of fraud. That's fallen by the wayside. Yes, mea culpa. He made a mistake. I can understand why they were annoyed by it, but they suffered no harm whatsoever. And a jury under these circumstances could find that it was not unreasonable.
I want to respond to your comment about no harm, because even if we're assuming, we assume there's a breach, then that would be a separate question whether there's harm. But they certainly make the argument that they would not have agreed to pay the price they did for the company if they had known this, and that they would have negotiated for a lower price, and that they lost that opportunity to do so because those costs were never disclosed to them in violation of the agreement.
Well, that's impossible. The agreement was signed first. None of this issue, there was no
Well, the agreement was
2020
signed
budget.
first, but the agreement said you have to give full disclosure before the closing. And if that disclosure had been given, that could have given them a basis for renegotiating the
Absolutely
price.
not. There's nothing, they did not have a base, if we had answered correctly, if we had said, yeah, we're planning, we have $500,000 in non-annual maintenance in 2020, they would have no recourse whatsoever. There was nothing in the agreement that said anything about what we could budget or not budget for non-annual maintenance. There's no reps about the state of the underlying equipment.
Couldn't they have said,
All of
"Well,
this
look,"
happened after they already
Couldn't they have said, well, look, you underrepresented what those costs are. We're not going to closing unless we get an adjustment for it.
No, because the alleged underrepresentation came after they already signed a contract with a price.
Before closing, and there is a requirement to provide documentation and access to records. What's the reason for that? If not because there's
well,
the
the reason is-
possibility of just this sort of situation developing.
I don't think so. The reason is, I think the reason that it actually says in that section, which is to enable them to basically understand the business so they can hit the ground running when they take over. But there was no requirement. If this had happened before they signed, yeah, it would be a very different case. But they signed a contract. They said, we're going to pay $35.8 million. They had every opportunity to inspect. And there was no, after that happened, they had no ability to say, we don't like the fact that you budgeted for this maintenance
Let's hear
in
from the other
2020.
side, and you'll have time to respond in rebuttal.
Good afternoon, Your Honors. Quinn Disa for Pan West NCA2 Holdings LLC. Focusing first on the NAM
Could
cost.
you address your adversary's last point, that there's nothing you could have done, and that the provision providing for access to books and records does not make reference to the possibility of an adjustment, but rather to the understanding of the business and integrating the business into buyer's organization following the closing. So there isn't a sense here that this is provided in order to allow you to make a claim for an adjustment for this.
Yes, Your Honor, first, as my friend here said, right, the purpose of this section was so Pan West could hit the ground running. So when we took over the facility in January of 2020, we found out that the facility needed $580,000 more in expenses than what we had budgeted. That impacted ultimately our crediting financing that led to more damages down in the future. However, specifically, a breach of that covenant under 6.2A takes us to 8.2D, which any breach of a covenant gave Pan West the right to refuse to close. That means Pan West could have refused to pay the $35 million purchase price that it did pay at the end of January. It could have refused to close. It could have asked Rockland, please, let's go back to the negotiation table. We were unaware of these costs. We'd like to lower the amount. That's exactly what Justice Borak said in his decision, that additional discovery needed to be done between the parties as
You're
to
saying
what
you
would
would
have
have had
happened.
the right to cancel the agreement based on that failure to disclose the information to you.
Yes, Section 8.2D is clear that Pan West had the right for any breach of a covenant. So either 6.1L, which is a breach of approving more than $50,000 in capital expenditures, or Section 6.2A, which is the breach for providing reasonable access to books and records to assist Pan West with its incorporation of the business. I'll note that no argument was made before the Supreme Court about the meaning of what reasonable access was. That is a new argument made by appellant on appeal.
And reasonable access, in your view, does not mean physically going to the facility?
No, our client certainly considered having a budget for the facility as being provided a budget as reasonable access to understanding and integrating the facility into Pan West's business in the future.
So as a cross appellant, you also believe the court should have granted you summary judgment on the pond claim, correct?
That's correct.
They failed to disclose the pond survey that would have given you real information about the so-called freeboard requirement, correct?
Yes, that's correct. And I'll just note, if you look at record R309 4 through 5, you'll see that NACE, which is the facilities operator for Rockland at the time, when they first reviewed this topical survey, which Rockland got 3 different versions of. At first, they argued that it wasn't a final report. Eventually, through discovery, we found that there were 3 versions. Rockland went back and forth, and they got a final version. When NACE reviewed that final version, they emailed Rockland and said, this confirms what we thought all along. The freeboard is in violation with the permit condition, B.NSO.8, which requires the pond's freeboard to have 2 feet of freeboard at all times.
But it didn't grant you summary judgment on that issue.
And
I'm
Your
not sure
Honors,
what it did grant you summary judgment, but it didn't grant you full summary judgment on the issue.
Justice Borak went all the way but to grant us liability. Now, I think he was focused more on Section 9.4, which is a requirement that there's a $300,000 cap as to the damages that PanWest would have, right? And at the time of discovery, we had produced in actual costs $100,000 and a projected cost of almost $3 million. At the time of argument, and as we said before Justice Borak in a lengthy oral argument, those costs were ongoing and had exceeded that $300,000 threshold. Now, we made an attempt to add those documents to the records, which were denied, and if we are not found for summary judgment as to liability because of a prevention on 9.4, we're confident that the actual costs exceed that $300,000 limitation.
If you get summary judgment on liability, you'd have to have a hearing to determine what the actual amount of damages are.
Of course. Yes, Your Honor. If there are no further questions, I'll rest.
With respect to the NAM costs, my friend said, well, if you look, there's an email on the record where they say this prevented us from understanding the business. First of all, if you go to that email, they're not talking about the non-annual maintenance. They're talking about the major maintenance. Second, how can you get summary judgment in your favor just by pointing to an email that your own client wrote? It's not even an admission by my client.
Counsel, there's no dispute that those NAM costs were not disclosed. That's not in dispute, right?
Well,
so the only question is, what is the legal effect of the failure to disclose something which was required to be disclosed?
There's nothing to disclose. These are maintenance issues that someone could say we're going to budget for them in 2020. They could do what they did, which is said notwithstanding that
Right, but
budgeted.
it's part.
There's nothing to
There's a requirement to disclose all
Books and
books and records, and that would seem to be something that would be in the books and records. That would be required to be disclosed. Well, I don't know how you could carve that out from a requirement that you have access to all books and records.
I'm not the one asking for summary judgment. I'm simply saying that there's a reasonable view of the evidence where a jury could say that they were not deprived of reasonable access. Because
How? If it's undisputed that they were deprived of these books and records relating
Not
to
undisputed.
the NAM course, how can that not be, as a matter of law, a breach of the obligation?
It's not undisputed that they were deprived. They knew about all of the underlying maintenance. The budget could have said anything. We didn't have to budget for it. It's just a forecast. And the second they came in, they threw out the budget and they decided for themselves what maintenance to do.
I have another question about the pond claim. Now, if the permit requires, at a minimum, 2 feet of the freeboarding of the reservoirs at all times, why wouldn't the plaintiff be entitled to summary judgment on the issue of liability? Because clearly, it wasn't the, 2 feet.
Well, no, that's not clear at all.
Really?
The evidence that they cite is deposition testimony of my client saying, yes, I'm aware that there were times when it wasn't 2 feet, and when it was less than 2 feet, we took steps to mitigate, which is exactly what you're supposed to do. It cannot possibly be the case that if the freeboard is exceeded for 1 second of 1 day, that's a breach of the permit. There's ample evidence that's not true. I mean, there's testimony by the CEO of the plaintiff who says, we have been in continuous compliance since the day we closed for 2 years just by having Pabco next door take more water for dust suppression, so there's less water in the pond. I mean, there's the DCNR report from December 2020 where they say the overall condition of the pond is fair, and over the next 2 years, which turned out to be a lot longer, you should ensure adequate storage for operation, and we consider this a maintenance issue. I think a jury would be entitled to take the state at its word and say, yes, the condition is fair and it's just a maintenance issue, and not the reading that they're urging, which is that the jury would have to say, oh, this really means that there's a material noncompliance with the permit.
Thank you.
Thank you.
Your Honors, I want to pick up on that last point, right? This is not just a maintenance issue. Rockland understood in 2018 when the pond completely drained of water and evaporated, that there was too much sediment in the pond. Then in the fall of 2018, they've got a report that showed around a $2.1 million cost to remove all of that sediment. Then in 2019, they got a report from Imperia Partners that said, here are some countermeasures if you don't want to do those items. All of that showed that there was a continual issue with the pond as to its sediment and freeboard compliance. They then went out to get a survey to say, is our freeboard incorrect? And when NACE reviewed that survey, it was incorrect. Further, in contravention of the permit required disclosure of all non-compliance. This isn't an issue as to whether or not there's a violation of the permit. What they warranted and represented was compliance. And this pond was not in compliance with its permit. And Rockland knew that. Rockland took significant efforts hiring 5 different environmental service providers to figure out what would be the cheapest and most effective way. And while doing all of that, they disclosed none of it to PanWest. Even though at the end of the fourth quarter of 2019, they knew and they emailed with the plant's manager that it should be disclosed on their DMR reporting report that the pond was not in compliance in the fourth quarter, which is the due diligence period of the MIPA, they chose to kick it to PanWest. Now, if they had affirmatively reported that before PanWest took over, do you not think PanWest would have seen that document and under the requisite section 8.2, I believe it's C, we would have also had the right to refuse to close or to renegotiate. All of these things were hidden from PanWest despite Rockland's true knowledge. And one last point I want to get back to onto the NAM costs. The books and records demand does not need to state that this is for the purpose of PanWest integrating the business into its future operation. PanWest made this request repeatedly before the MIPA was entered and after the MIPA was entered for books and records related to the operation of the facility. And Rockland's corporate representative and William Path all testified that when they make a budget, everything within that budget is sent to NACE, agreed to with NACE to be incurred by the facility for 2020. Approval does not mean that it cannot be rescinded later, and that's what PanWest did. Thank you, Your Honors.
Thank you very much.
John is no longer with.